Hello, I'm Luke Carlson from LS Carlson Law. We are a law firm that operates both in California and Florida, and one of our major verticals is HOA law. And today we wanted to take some time to review the CNBC video that really focused on HOA. I want to start by applauding them for really highlighting this area that has really been a point of great contention for a lot of homeowners. However, our take is that it was very one-sided, basically painting out the HOA as having all the power, which we strongly disagree with. So we're here today. Again, I'm a lawyer, but I also brought my wife, Jenny Carlson, on as well.
Hi there.
Hi. She's a non-lawyer, so I thought it'd be helpful to have both sets of minds looking at this and really dissecting it.
Absolutely. Thank you for having me.
Anytime. You're always welcome on the show. All right, here we go.
84% of newly built single-family homes sold in 2022 belong to what's called a homeowners association, which are organizations that oversee properties in a community.
Certain local governments require almost all new construction to have an HOA.
They're rooted in the desire for municipalities to offload their responsibilities for taking care of things that you would normally associate with paying your taxes.
Homeowners associations provide value to owners.
But they're
All right, so far so good. I think that was straightforward. We're aligned. The only caveat I would say is, yes, well-functioning HOAs absolutely preserve fair market value. They drive value.
100%.
However, the flip side of that, though, is if you have a bad HOA, that can tank fair market value immediately. I mean, you have common areas that are dilapidated. That's going to drive the values down. So far so good, though.
There's been a backlash to HOAs because of some homeowners' negative experiences.
When I first bought this house, I was very excited. Seemed like it was a very nice, cozy, close-knit community. Then it started turning into a horror story.
I'm a huge believer that, you do sign away your civil rights when you're signing into an HOA or a condo association.
Wait, pause it there. Do you really sign away your civil rights?
All right, so that's one of the largest overstatements, I think, in this entire thing.
Okay.
So, what are civil rights? You're looking at right of privacy, right to freedom of religion, freedom of speech. I mean, there's so many civil rights that are so well intact, notwithstanding CC&Rs.
Okay.
So that is a huge misstatement. You're not signing away your civil rights. The Constitution is always going to trump CC&Rs
100%. Okay.
every single day. So that was crazy.
It's a matter of personal preference. Some people like anchovies on their pizza and some don't. Some people really like living in homeowners associations. Others don't like it.
So why are HOAs so powerful? And do they make homes more valuable? Homeowners associations are run by a board of directors that's made up of volunteers who own property in the community. The HOA typically handles communal responsibilities, which can vary from managing amenities such as swimming pools to making sure property owners follow home maintenance rules. The board may hire a management company, which tend to be for-profit, to help run the day-to-day operations.
Yeah, just a quick clarification on that. A lot of times we have homeowners or clients who come in and they're furious about the management company.
Okay.
Right. And they often want to sue the management company. But legally, at least in California, that's an incorrect way of looking at it. The management company is just an agent for the HOA. So the HOA is guiding the management company.
Okay, I think that's a common misconception, so I'm glad you're clarifying that.
Yeah. So if you have a management company that is failing to maintain common area elements, the suit would actually be against the HOA, not the management company. Because
Okay.
the contractual relationship is between homeowner and HOA, not
Gotcha.
homeowner and management company, if that makes sense.
It does.
Homeowners in the community pay into a fund for the HOA to have an operating budget. In the U.S., the typical home in an HOA pays between $200 and $300 per month in fees. HOAs have the authority to hand out fines to residents in the community that the association feels is not following the rules. Those fines may also accrue interest in some cases. The Innistrosas' annual dues for their HOA in Noonan, Georgia is $200 per year, which is lower than the national average. So on paper, their HOA membership doesn't seem like that much of a financial burden, but that's not been their reality.
When we moved in 2008, we found out that there was a balance that was attached to the home because it had been sitting in the community, and they were fining us for that balance and late fees and any other type of fines that they would put onto the home for lawn care or anything.
Wait, yeah, clarify this, because when you buy a home, doesn't it have to be disclosed?
So California, if you were to acquire that property, there would have been a disclosure.
Okay.
And really, it would have been two disclosures. One, that there was some sort of outstanding balance that wasn't satisfied by the previous or the seller.
Okay.
The other issue, and she says it quickly, she says lawn care. So what I'm betting is that there was some sort of open violation that wasn't addressed. So maybe the lawn was in a state of disrepair. The HOA was levying fines against that homeowner because they failed to maintain a common area, or not the common area, but the actual landscape.
Okay. And if those fines accrued, the new buyer is responsible.
Well, it would have been disclosed and it could have been dealt with at the time of acquisition. For whatever reason, it wasn't disclosed. Now in California, it's possible she would have had a cause of action against the seller of the property for failing to disclose.
This is in Georgia.
Is it?
Yeah.
Okay. I didn't catch that.
All of that was attached to this home when we moved in.
From 2008, 2014, we tried to get in contact with the HOA, and we never had a reply from them. And we just kept trying and no answer.
All right, that's a big red flag right there. HOA failing to communicate with a homeowner. That right there would accrue rights from the homeowner.
And the hope is that is an atypical scenario.
No, it's very typical.
Oh,
we see it
really?
all the time in California. No, I mean...
Hence why we do HOA law.
Yeah, HOAs are notoriously poor at communicating, and some go so far as to intentionally fail to communicate so they can run some sort of scheme behind, just basically levy fines.
That's fascinating.
Yeah, so we actually do see that quite a bit.
By August 2015, the HOA put a lien on the Inestrozas' home. In the court documents, the HOA said the Inestrozas owed more than $1,600. A lien is when a party has a legal claim to an asset, such as a home, which can serve as collateral to satisfy unpaid debt. This can open the door to the HOA escalating to the next level of debt collection, such as foreclosing on the home or, in the Inestrozas' case, garnishing wages.
In mid-2015, they started garnishing my wages. The first time I learned of that was when I got my first paycheck that they garnished.
Okay, so
Please explain that.
so now you're actually kind of outside of HOA law. You're almost into unfair debt collection practices because, again, I'm speaking for California, but there are very specific code required notices that you have to receive before you can even garnish a wage, before you can lien a property. So what it sounds like happening here is that someone, most likely the attorney, is violating those rules if this is accurate.
Okay.
I didn't get any prior notice. I got a notice 2 weeks after.
Even though the HOA was
Pause there. So
collecting...
if she didn't get any prior notice, we have lots of room for error here.
Well, yes, room for error, but I think better said, they now have power to enforce, right? Certain rights have been violated. So again, this is sort of painting them out to be a victim, but with proper legal counsel, they could have pushed back very hard on this.
Okay.
They're sort of on the receiving end of this, but it sounds like a lot of their rights have been violated by the HOA, by the attorney collecting the debt. And
they do have power and justification to go after their HOA at this point.
in this scenario, it looks like they would.
Okay.
Yeah.
From Jules' paycheck, invoices filed with the court showed they were adding fines rather than deducting from the overall balance. By December 26th,
I didn't catch this before, but it's landscape maintenance that keeps getting flagged on this ledger. So I would imagine that there's some sort of outstanding violation potentially. Again, that doesn't negate the fact that they're probably collecting these fines illegally or there was a failure to communicate, but there might be an open and outstanding violation.
Okay.
16, the HOA said the Inestrozas owed more than $4,300.
In 2016, I decided to go into debtor's court. My attorney and the HOA's attorney came to an agreement that I would pay $3,200. We paid in installments, and we finally paid that off in January of this year.
But it seemed like never got to the management or the homeowner situation. Just adding fines and adding interest. That's all they was doing.
Okay, so lack of communication between parties?
No. I see this is odd. I think this is one of the more odd parts of this video. Typically, when there's some sort of negotiation amongst attorneys, right? There's an outstanding debt. Their attorney's going to say, well, it's lower. They're going to say it's higher. They meet in the middle and they find a number.
Okay.
Well, here it sounds like they reached some sort of settlement or resolution.
Correct.
And there was a fee schedule.
And they satisfied the fee schedule.
Well, according to them, typically those are in writing. So assuming their lawyer did their job, memorialized this agreement in some sort of written agreement, instrument, and the HOA continued to collect after that agreement was entered into, these guys now most likely have a breach of contract claim.
Okay.
They're violating that contract or that resolution that was entered into. So again, there's more to this story. I don't know what's going on here.
There has to be.
So they were still saying that I owed almost $8,000 while my attorney and their attorney agreed on $3,000 something.
Again, right here, you would just send the settlement agreement, have the attorney call their attorney and say, stop collecting on this. We've satisfied it. Go kick rocks.
Okay.
Done.
Yeah.
But I don't know why they continue to pay.
The Innistrosas estimate that they've paid about $12,000 in fines and garnished wages to the HOA, along with thousands of dollars in legal fees to their own attorneys. The latest invoice they received on August 18th, 2023, says they still hold a balance.
Even after paying $12,000, they're still saying that we owe them $8,000.
After the past, 23, after the past 10 years. 10 years, yeah.
CNBC reached out to Homeowners Management LLC for comment and received automated responses directing us to contact the current management company as of August 2023. A representative from the current management company, Century Management, told CNBC, because it just became the management company for this community in the last couple of months, Century has little ability to comment on historical facts regarding the Innistrosas case. The former director of the HOA board, who oversaw the association from 2020 until her resignation in October 2023, declined CNBC's request for comment.
I find it funny who they're reaching out to as well. So you have a former management company. They don't care. They're not going to comment.
Right.
You have a new management company. They're not going to disclose anything. And then you call the former board member, who was most likely just some volunteer who was on for a short period of time.
Yeah, they're not going to respond.
Yeah, some intern wasted their time reaching out to these people. I mean, you might as well just reach out to the gardener for comment.
The attorneys representing the HOA board did not respond to CNBC's repeated requests for comment.
All right, that also doesn't surprise me. I mean, if this was accurate that the HOA is trying to go after this homeowner, illegally assess fines, failed to do notice requirements, I would imagine that the attorney who engaged in that, I mean, if it was California, I mean, they're violating certain rules of professional responsibility. I mean, they could have some exposure there. So it doesn't surprise me that they're not commenting. Why would they?
Jessica Navas and Matt Bazzone, who are also homeowners in the subdivision, began investigating their HOA.
I started to have this feeling that there was something odd about the HOA during the pandemic.
They discovered a history of at least 25 foreclosures in the community over the past 15 years.
Just one house can have a record between 2 to 3 foreclosures within that time frame.
So I applaud people like that in a community. I mean, someone like that is actually seeing something is wrong.
And they're taking action.
Yeah, they roll up their sleeves and they look under the hood. I mean, that's powerful. That's impactful. And I think, too, if more homeowners did that and actually were a little bit more proactive with their rights, you wouldn't see the dumpster fires that we see today in a lot of these communities.
Jessica hadn't just took the initiative to go to everyone in the community that she knew were homeowners, we never would have known any of this, because all we did was basically go to work, come home, raise our children, that's it. And we never knew that anybody else was going through this, because for the longest I felt like, is it just me?
I feel like HOA could be a positive thing when the community work together, keeping our houses looking good and good for property value.
A big part of an HOA sales pitch is that the presence of the organization can help increase property values.
The board is responsible for protecting property values. For most people in the United States, the single biggest investment they're ever going to make.
There's mixed evidence about whether this is true. A 2019 study found that on average, HOA homes cost at least 4% more than non-HOA homes. That comes out to an extra $13,500. But those property values can vary significantly by location. A different 2019 analysis of 3 U.S. cities found that the home values in HOA areas were less than those in neighborhoods without them. The Innistrosas' property value has increased between the time they bought it in 2008 following the housing crash to 2023.
I mean, I'd hope so.
Yeah, gosh.
I don't think that HOA has anything to do with our property value going up.
I feel with the HOA, the management company don't increase the property value. They're just there as employees, the community that increase the value of the property.
HOAs can also be necessary in order to manage shared amenities or land, which can be a value add for homeowners.
There are associations out there that handle all the landscaping. Even though you may own your lot, the association cuts the grass and they do all the landscaping. So is that a cost saving? Sure.
Management companies can help a community function.
All right, I find this shot very funny because to me it kind of sums up. I mean, if you're a well-run HOA, you're preserving curbside appeal.
100%.
Right.
Think of our neighborhood
Yeah.
specifically. We have the lawn areas, the park areas, the pool.
And they're very well maintained. I think they do an
Absolutely.
exceptional job. If you look at this photo, though, it's interesting because if you look at this street where you drive in, the grass is very green, everything looks very
You
nice,
see
well
the lush
maintained.
trees.
And then look at the backyards. It's
They
like
look
a
like deserts.
So I think that could be a good example. I mean, if people are left to their own devices, yeah, sometimes homes fall into a state of disrepair. If you're living next to a junk home, your property value is going to go down. So again, well-maintained HOAs, or those that are abiding by their fiduciary obligations, complying with the CCNRs, they have massive impact in a positive way.
I'm sure there's a huge differentiation between good HOAs and bad HOAs. And if you have a good HOA, I feel like the curbside appeal and the preserving home values is going to be 100% a positive thing for you.
I agree.
Smoothly, especially when a board of volunteers needs assistance.
One large company will manage 20 or 30 or 40 HOAs in a region, and they tend to have it down to a science. They know how to deal with trash pickup, they know how to deal with yard maintenance, they know how to deal with complaints, they have their fines and their enforcement down to a science.
Relying too much on a property management company is going to cause problems, and relying too much on the homeowners to run their own association is also going to cause problems.
The management company and the manager are simply a contractor to carry out the board's direction. They may handle all of that routine activity on behalf of the board, but those folks who live in the community and volunteer remain the decision-making authority.
Yeah, that was going back to what I was saying earlier. Management company is just a contracted third party, right? So
Right.
when you're the HOA ultimately is the final say.
Okay.
So if a management company is malfunctioning, right, they're not doing their job, HOA has a responsibility to cut that management company, to remove them and find one that is capable.
And that is the responsibility of the homeowners or
No,
the
the
board?
HOA, the board.
Okay.
The board has the power to do that. And again, if the board is failing to do that, now the homeowner has the right to bring that grievance against the board for failing to
Okay.
act, right?
And that's something maybe we can get into a little bit later when we dive into this, but that's an interesting point. So remind me to come back to that.
The board in that situation is still responsible. They are still the fiduciary. They are legally and financially responsible for the decision making in that community.
All right, fiduciary is a huge deal, and they don't really harp on that. But when the board steps in, or you have a board that's been elected in, they have a fiduciary obligation to the homeowner, a fiduciary to preserve fair market value, to act in good faith, to comply with the CCNRs, to ensure that the community is running properly.
Okay, just in layman's terms, define CCNRs real quick, just in case people are watching this and need a refresher.
Yeah, well,
Someone like me might.
CCNRs are essentially the code, covenants, and rules of the community.
Okay,
or the
and that's kind of
the
like what we
regulations.
sign into when we buy the
No,
home.
correct. And it's a contract within the community, and it contractually binds not only the homeowner to the HOA, but also neighbors to neighbors.
Okay, so if there is an issue, is that what the first thing I'm going to look at?
That's going to guide the entire analysis, the
Okay.
CCNRs. Now,
So it's everything.
it gets a little complicated because you have the CCNRs, then you have state regulation. So in California, you have the Davis-Sterling Act, and then you have case law. So it's really three areas of power to enforce that you have to look at all three.
Okay.
And so you see a lot of real estate attorneys who kind of dabble in HOA law. They often hit tripwires because all three bodies interconnect. You have to triangulate the CCNRs with the Davis-Sterling Act with relevant case law, which interprets sort of the two. So
Interesting.
it becomes a little bit complicated, but yeah, CCNRs are very powerful.
Okay.
I think that there are times and places for HOAs, and I think that they could be positive. But the abuse negates that benefit.
A lot of people have trouble thinking of community associations as a business, even though statutorily, in many cases, they are. You have to think about it like running a business. At the same time, you have to think about it from the perspective of a group of investors who all have this shared goal of making sure their investment's safe. And nobody's quite sure how to do that. And when you bring in an outside advisor to help run your organization, those people's goals are not the same as the goals of the people who made the initial investment.
I don't agree with that. I think he's wrong, and I'll tell you why. Most companies, Fortune 500 companies, bring in advisors. Those advisors come in and they're incentivized to, ensure that the company is running well, is well maintained, is functioning well from a procedural level, from an economic level, from a market level. And why are they incentivized? Because they want to keep their job.
Right.
They're economically incentivized to do a good job. And if they don't do a good job, they lose their job. So
and people can change.
So the fact that there's a misalignment there in terms of goals, I tend to disagree. I mean, a good management company wants to do good for the community because they want to stay a contractor of that community.
100%. Okay.
So to say something different as if, the management company has some ulterior motive.
It would benefit no one to have different.
Correct.
Okay.
Professional involvement in HOAs is increasing, with the for-profit homeowner association industry growing to $38 billion.
Really
Jessica and
emphasizing
Matt
that
have been
they're
fighting for more
for-profit.
transparency about where their HOA fines are going.
We had 4 months of pulling teeth. We wanted a general ledger, but they gave us a balance sheet and a budget.
We contracted a forensic auditor, CPA. It is very concerning to see that the amount of income that they're receiving is coming from these particular aspects: fines, citations, collection, legal fees. And her recommendation was remove the board, freeze the account, get access into the bank account.
I mean, before talking to a CPA, she probably should have spoken with an attorney, but whatever that's worth.
The numbers don't align with each other.
In most cases, association management companies charge a flat fee for their management services for the association each month. They're not getting a share of the proceeds. That's not how they're compensated.
If we didn't have a management company, we wouldn't have to be dealing with these different problems that we're.
I tend to disagree. I mean, listen, it was a poorly run management company, but ultimately the buck stops with the HOA. The HOA could have taken action, could have severed the management company, could have brought in a new management company. I wouldn't say it was, because there was a management company and they were a poor management company.
Right,
that
it's a
resulted
very
in
general
this.
statement.
Yes. And I think there was also some collusion possibly with the attorney. I don't know if the attorney was incentivized to levy those fines and to lien up the property.
I'd be curious to dig deeper into this and see.
Yeah, surface
facts.
level doesn't all add up to me.
We're having. Basically, they're just milking the community.
The Inostroza's experience with their HOA highlights some patterns seen across the country when it comes to how much power HOAs have. 57% of homeowners polled disliked living in an HOA, with more than 3 in 10 homeowners saying they feel like the HOA has too much power.
People need to understand how much power a board of directors has. Governments are giving the power of the municipality to these communities.
They act as hyper-local governments and in many ways supersede all the other laws that exist when you sign into a covenant that runs with the land.
Covenant.
Okay, so there's a lot to unpack. And from an attorney's perspective, they are just, I think they're just dead wrong. I mean,
From a layman's perspective, it sounds like the HOA has more power almost in the state there.
Well, they're trying to. I think they're trying to pitch this as, once you sign into a CC&Rs, you're waiving all of your rights. You have no power to enforce.
Yeah.
You're powerless. But the reality is when you sign into or when you enter into a homeowner association, your power comes from the CC&Rs, meaning the obligations of all parties are laid out there. When an HOA is in breach of that, you have the right to enforce the CC&Rs against that HOA, right? It's not like
that's not even brought up.
You're right. You're not waiving rights. Let me back out. You're waiving certain rights. You're waiving the right to, color paint your house fuchsia or zebra or some crazy color scheme. I mean, there's certain standards, yes, that you have to comply with, and you know that going in though, because you can read the CC&Rs before you acquire.
Correct.
So there's certain things that you are signing away and you're giving up. You're giving up the right to maybe
keep your Christmas lights up year round.
Correct. You are. But they're seeming to suggest you're giving up, well, they are not seeming to suggest, they've expressly said civil rights, which is wrong, but they're also painting it as if you have no rights against an HOA who is really acting wrongfully.
That's what we call a bad HOA.
Bad HOA.
Covenants is shorthand for covenants, conditions, and restrictions, or CC&Rs. These are documents that outline the HOA board and homeowners' rights and obligations. A homeowners association usually enacts the CC&Rs as well as the bylaws that outline procedural matters when it's incorporated by the subdivision developer.
The board in the beginning is controlled by the developer. So it starts out as a board of people that are paid on behalf of the developer to operate that community. And it transitions 100% of the time. In some cases, it takes years. In other cases, it might only take 1 or 2 years to a set of volunteers.
Homeowners who have
wait, that is so interesting because I had no idea.
Well, think about it. I mean, when you first develop land, there's no one living there, right? So it's the developer who comes in, buys the plot of land, subdivides it, builds the homes, And then in order to, create an HOA or an association, you have to form an entity, a legal entity, right?
Okay.
You register it with the state. And then to govern that community, that's when you enact the CCNRs, et cetera. And that's the developer. So if you look at most CCNRs, it's typically signed by the developer. And once people start buying and acquiring and a board comes in, the developer then turns that all over to the board.
So then they transition to a board of people in the community.
Right, because the developer doesn't want to stay intertwined or intermingled with the community. They want to flip it, sell it, and get out. But it does take time sometimes
It's
to
just
do
interesting because I had no idea.
Yeah,
I'm sure most people don't.
That's the genesis or the origin story of HOAs. Starts with the developer. But again, go to the CCNRs. You'll see the developer typically is the one who signs them.
Disputes with their HOA say they have trouble getting help from official government channels.
I have personally contacted the city officials. None of them want to get involved in the HOA.
There are only 7 states that have an Office of HOA Ombudsman: Colorado, Delaware, South Carolina, Florida, Illinois, Nevada, and Virginia. However, the Ombudsman office is usually not very well funded, and they have limited jurisdiction over the types of complaints they can take. And in some cases, that's all the Ombudsman office can do is take your complaint. They can't even take an active role in investigating or resolving the complaint.
As far as the regulation goes, I think a lot of that regulation is predetermined. So in other words, there's already laws that are set up in place. And so inherently, they're already being regulated that way. And of course, you've got the court systems for checks and balances in case you have a disagreement within your homeowners association.
I think that education is really key to these communities. I mean, they need to know that there's nobody that's going to help them, that in a lot of cases, civil court is the only answer. So you can't even...
Isn't civil court supposed to be the answer?
Well, okay, so I'll unpack this one as well, because they say a lot of things. And sort of the messaging in my mind is, hey, there's no one who can help us. There's nobody, the government's not going to help us.
Well, explain this, because aren't these private parties?
Well, private parties, exactly. So let's say you have a breach of contract claim against someone, you lend them $1 million, they don't pay you back. You don't go to your state government and say, hey, this person owes me $1 million. That's not their function.
Right.
The branch of government, it's the judicial branch. That's where you get recourse from. And they're acting like that's nothing. That's like saying, I have no weapons other than a nuclear bomb, but other than that, I have nothing. That's insane.
Okay.
Because the redress is by way of the court system. That is a very powerful tool.
It is our tool, right?
That they seem to be like, well, other than that powerful tool, we don't have any tools. And the government isn't helping us. Well, that's not really their job to help them, and especially when it's a private matter.
Okay.
And take some of these communities to small claims court.
There's really a very limited number of scenarios where a court can say that something that's binding in your covenants is not valid.
That's also sort of an odd statement. I mean, if something in the CCNRs violates state or federal regulation, a court can absolutely decree it invalid.
Okay, thank you for clarifying
that. So that guy probably isn't a lawyer.
Lawmakers in several states, such as Texas, North Carolina, and Florida, have introduced policies to address some of the issues homeowners have been raising. But it's been met with backlash from the professional management industry.
There's always going to be a wide variety of perspectives and concerns. So no solution, no bill, no piece of advocacy is ever going to garner 100% support from everyone. We try to find the best middle ground that makes sure the association runs effectively and people's investments are protected.
So I sort of disagree with that. I don't think we're always looking for middle ground. So this firm right now, we're working on legislation right now that is really to drive deterrence and increase penalties for an HOA that's acting wrongfully. Because if you think about it, if an HOA is well functioning, abiding by their fiduciary, abiding by the CCNRs, then if you amplify the penalties of a bad board or a bad association, why would a good association care?
It's so true.
Right? So you penalize. You amplify what you can seek in terms of damages. You put in treble damage clauses. You just amplify the ramifications of misconduct. That, in our mind, that's why we're working on the project right now, is to drive a situation where a good HOA is not going to care about that because they're a good HOA.
Exactly. They're not going to worry about amplifying it.
Yes. The only ones that care are the bad HOAs because they're like, well, we don't want to get hit with treble damages or punitive damages. I mean, that's insane. Well,
yeah,
good.
That makes sense.
Right?
As of right now, change has to happen at the grassroots level, with homeowners fighting through the court system as well as through voting for a board they feel represents them. Matt was elected president.
Right? Voting for a board that represents you.
Well, I think voting for the right people, I agree. But again, it does involve community involvement. I think that is important. And just finding individuals who aren't out on their own mission, which you see frequently. I mean, you see certain characters over and over again in these disputes, where you have the one individual who's just power hungry. You have someone who's a meddler who just wants to meddle in everyone's business. You have someone who has way too much time.
These are not business people on the
Typically,
board
no.
of HOA, not usually.
Typically, no. And that causes a lot of the problems because they're volunteers. They think it's just kind of cool and fun, but they don't realize what they're actually stepping into, again, is a fiduciary role that has contractual obligations around it, that's governed by state law, right? And then case law. That is a huge position to undertake. And if you're not serious about it, you're going to run into problems. And I think that's why you see so many problems.
No, exactly.
Of the board in October 2023.
So these are your new officers. Thank you very much.
I did the oath when I became a naturalized U.S. citizen. It was my duty. And regardless of my economical condition, I have to fight for them.
I would feel bad, selling this home to someone else, especially if they don't know what's been going on in the neighborhood.
Well, you won't feel bad because you're going to disclose it, hopefully.
And I feel like I would probably just be like, hey, look, I don't think you want to move in this neighborhood. You may want to think about it.
All right. So I think the key takeaway or what we were trying to convey to everyone is that homeowners have much more power than this video makes it seem. And again, it was, I think, just sort of the tonality of it, which they wanted to present the HOAs as this big bad wolf that are all powerful. But the reality is homeowners have tremendous power. Again, it's by way of the CC&Rs, it's by way of the fiduciary that the board owes the homeowner, it's by way of state law, and it's by way of case law.
Okay, so as a homeowner, if you have an issue in your neighborhood, what is the first step that you should take other than looking at your CC&Rs? If you feel like there is negligence or there is some level of misconduct, what should my next step be?
Okay, that's a fair question. I'm going to frame it in California.
Okay.
So two things. One, I mean, if you have a board that you think is just sort of acting wrongfully but unknowingly, they're not necessarily malicious, you may want to start with what's called IDR, which is informal dispute resolution. And under the Davis-Sterling Act, you can just send an email to the board and request IDR.
Okay.
Right? Let's say they're failing to maintain a common area element. You send them an email, and what that actually boils down to is just a meeting with the board, typically in a clubhouse or someone's residence, where you can talk about the issue. Now, if they stonewall you and you're not getting any movement, or in anticipation that sitting down with them is going to be useless, there's other methodologies that you can use to really start enforcing your rights. Typically, it's not litigation. You don't start normally with a lawsuit.
Okay.
A very effective means to enforce your rights is through what's called ADR, which is alternative dispute resolution. And it's a powerful tool because if you have a grievance with the board, you can actually demand that they attend mediation with you.
Oh, interesting.
Yeah,
Okay.
and mediation tends to be a great way to resolve disputes with homeowners.
Do you need a lawyer, an HOA lawyer?
I would recommend one. They're going to have a lawyer.
Okay.
So if you're going to go to bat, you might as well bring an advocate. You don't need one by law, but it depends, I think, on the seriousness of the violations and what you're going through. It's case by case.
Interesting. Okay.
So, hope you guys enjoyed it, and thanks for watching.
Thank you so much.